Hello, everybody, and welcome to my PowerPoint for week 10 on different things in the government. I guess I don't really know how to explain what this assignment is, but let's get started. So, on the agenda today, we have the 10th Amendment, expressed and implied power, supremacy and elastic clause, how regulatory laws are made, enforced, and adjudicated, how do they fit, and how is the Constitution amended. So to start, the 10th Amendment ensures that states possess all powers not explicitly assigned by the federal government by the Constitution. The 10th Amendment is one of the first submitted to the states for ratification. It guarantees to protect states' reserved powers to regulate things such as marriage, divorce, interstate transportation, commerce, to pass laws affecting education and public health and safety. Express powers are powers that are specifically and explicitly granted to the federal government in the Constitution. The specific express powers granted to Congress and to the President were clearly spelled out in the Constitution under Article 1, Section 8 and Article 2, Section 2 and 3. And basically gives them powers to like tax, borrow, declare bankruptcy, commerce power, currency power, and it's what is specifically stated in the Constitution. Now, implied powers are powers that are implied, but they're not explicitly stated in the Constitution. So these powers are derived from the necessary and proper clause, which gives Congress the authority to make laws for putting into execution. Like an example is to include the creation of like a national bank and like the power to conduct investigations. The supremacy clause makes it clear that any conflict in law between the central, like the federal government, and the regional, which is like the state governments, are typically resolved in favor of the central government. So basically, like, one state can't tell the whole federal government what to do. Article 5 declared that the U.S. Constitution and laws or treaties made in connection with that document were to supersede constitutions and laws made at the state level. So basically, the federal law trumps state law. The elastic clause provides Congress to make all laws which shall be necessary for carrying like the execution and the powers. These powers stem from the elastic clause in Article 1, Section 8 of the Constitution. It's been used to support the federal government's role in, or playing a role in controversial policy matters such as provisions of healthcare, the expansion of power to levy and collect taxes, to regulate interstate commerce, and a bunch of other stuff. How are regulatory laws made? So they're made through a process called rulemaking, which begins with Congress passing an enabling law and then assigning it to an administrative agency. The agency purposes a regulation, publishes it for public comment, and then reviews the feedback before issuing a final rule, often incorporating like revisions in response to the public output. So they may like ratify what they said or put on it based on what the public has said. The process is defined by legislation like the Administrative Procedure Act, and it is designed to allow the public for participation before the rule is finalized. So basically, the government can't just make a law without getting the public's input. how are they enforced? So they're enforced through a variety of mechanisms, including inspections, administrative actions like issuing notices or fines, or civil or criminal lawsuits. They use strategies such as deterrence, legalistic enforcement, cooperative or accommodative enforcement to ensure compliance with the laws they are authorized to enforce. How are they adjudicated? They are adjudicated through either formal or informal administrative processes, often involving administrative law judges or ALJs. Formal adjudication resembles a trial, with a natural ALJ presiding over the hearing, where parties present their arguments and evidence. And informal adjudication includes a wider range of processing, like resolving applications for license or grants without a formal hearing, as long as the due process is met. So in my opinion, how they fit, don't fit, and what we need. So how it fits, it delegated legislative power, which is Congress creates regulatory agencies through statutes and gives them the authority to write rules that function like laws, interpret vague legislative language, fill technical gaps Congress lacks in expertise or time of the address. It's grounded in the doctrine of delegation, upheld as long as the Congress provides intelligible principle. Executive branch oversight. Basically, the president directly or through the Office of Management and Budget can appoint agency heads, direct regulatory priorities. Review. I'm so sorry. I lost my notes. Appoint agency heads, direct regulatory priorities, review major rules, enforce regulations. But like independence agencies like the SEC or the Fed have leaders who can only be removed for a cause. Judicial review. Agencies are subject to court oversight. The courts can strike down arbitrary or capricious regulations, overrule actions beyond statutory authority, assess constitutional violations. Regulatory agencies blur the line between like the three branches. How it doesn't fit, they combine the powers into one body. So basically, they make rules, enforce them, adjust disputes, and it contradicts the Constitution's vision of separated powers. Democratic accountability is diffuse. So Congress delegates authority, gives up direct responsibility. President oversees but loosely for independent agencies. Courts intervene only after the fact, like after things have already happened. Expertise in constitutional structure. Basically, agencies exist because modern government requires scientific, economic, and technical expertise neither Congress or the courts possess. But that very expertise makes them powerful and sometimes politically insulated. So basically, we don't need more agencies. We need clearer statutory guidance from Congress, better oversight, stronger transparency and accountability mechanisms, modernization of existing agencies to deal with like the 21st century problems. So in other words, basically, we don't need more agencies, we need better agencies. How can the Constitution be amended? It can be amended through proposal and ratification. So proposals can be amended in two ways, by Congress or by the states. Congress is a 2/3 vote in both the House and the Senate. The Senate. And the states have a national convention called 2/3 of state legislatures request. But it's like never happened. So ratification, it must be approved. The amendment must be approved by the states in one of two ways: by state legislators, which is 3/4 of the state must vote to approve, or by state conventions. Special state conventions approve it, which is rare. It's really only used for the 21st Amendment. Actually, sorry, it's only been used for the 21st Amendment. And some examples of constitutional amendments are the First Amendment, freedom of expression, the 13th Amendment, abolition of slavery, and the 19th Amendment, which is women's right to vote. So the First Amendment is part of the Bill of Rights, protects freedom of speech, religion, press, assembly, and petition, and it limits government power over individual expression. The 13th Amendment ended slavery, made involuntary servitude illegal, so basically slavery illegal, except as a punishment for a crime. And it was passed after the Civil War to eliminate the legal basis for slavery. The 19th Amendment prohibited states and the federal government from denying the right to vote based on sex. It granted women nationwide the right to vote, and it also was a major victory for the women's suffrage movement. Basically gave him equal rights as a man. Thank you. I hope you now understand each point better. You can explain it on your own. And I hope you enjoyed. Thank you.